In view of the above, impugned orders dated 16/11/2016, 15/9/16, 7/1/17 are therefore set aside. Matter is remanded back to the concerned respondent's prescribed authority, and this court permits the SSC to explain the causes of delay that may have had occurred in filing the refund application. These reasons, if and when furnished by the SSC, will be duly considered by the prescribed authority, and thereafter, if it is found that the petitioner has paid excess value-added tax, then the authority will process the refund application after consideration of the application as may be submitted by the SSC, explaining the delay, and thereafter pass appropriate orders. Any such orders that may be passed, copies thereof shall be served on the SSC. The entire exercise to be completed within a period of 60 days from the date of receipt of a certified copy of this order. But all writ petitions are allowed. But yes. All right, we'll issue notice on the IA. Heard Mr. A. Samuel, and Council Commissioner, applicant, Mr. G. Bushall, learned counsel appearing for the registry of the High Court, namely respondents number 1, 2, and 3. All the respondents. All the respondents. This IA has been filed by the petitioner. Seeking orders from this court. Seeking directions from the court to the respondents that the applicant be permitted to appear in the interview for the post of Assistant Registrar. Assistant Registrar pursuant to the notice dated 24th of October 2024, whereby interview was called inter alia for 3 within bracket anticipated vacancies of Assistant Registrar. Stop. Learned counsel for the petition applicant submits that notwithstanding the judgment of the division bench rendered in Writ Appeal 5 of 2023, dated (28/3/2024), which subsequently came to be confirmed by the Apex Court by dismissal of the SLP filed by the respondents in the said appeal. The respondents in the present application have refused to accept the findings of the division bench of this court, and as a consequence thereof, the petitioner's seniority in the post of court officer has been overlooked, and he has not been called for the interview, ensuing interview, which is scheduled to be held on 5/11/2024. Stop. Earlier, the petitioner had already had the writ petition. The applicant as a writ petitioner has filed this writ petition, being WPC 2755, putting to challenge the seeking a mandamus to the respondents to consider his name for the post of Assistant Registrar in the ministerial stream, and a further direction that his promotion shall be effected from the date on which his contemporary or junior ministerial staffs have been promoted, and a further direction to fix the inter se seniority of the petitioner This is not necessary. Stop. During the pendency of the writ petition, did you file another IA earlier?
Yes, yes, 1769.
Uh, During the pendency of the writ petition, an IA was filed, being IA number
69
1769
of 24.
of 2024, in which similar directions were sought for. No, where did we pass the interim order? In the writ petition?
Perhaps
Earlier,
In the IA, man.
Huh?
In the IA.
IA, there is no order.
then
1769.
maybe it is tagged with the main writ petition interim order. But that order was passed pursuant to the IA, maybe tagged with the main writ petition.
Don't you have a copy of that order?
My lord, that's page 10 of his, this IA, my lord.
The current IA, my lord, page 10 is there. No,
Where
it
by?
passed in the IA.
IA 1769 of 2024, seeking orders from the court to the respondents to permit him to appear in the interview for the interview and selection process for the post of assistant registrar, which was scheduled to be held in pursuance to an earlier notification dated 7/6/2024. Stop. This court, by order dated 11/6/2024, permitted the petition applicant to appear in the said interview. However, in the event he was selected for the promotion to the post of assistant registrar, such promotion and appointment order was not to be issued without leave of the court. So, para, during pursuant to the order dated 11/6/2024, passed in IA, this is IA 3290.
This is 329.
Huh?
Earlier one is
Oh,
1769.
Okay, 1769. 1769. Petitioner appeared in the interview, and however, subsequently, he came to be informed that he was not selected for promotion. Para. During the again during the pendency of the present writ petition, pursuant to the notification dated 24th of October 2024, a further interview for anticipated vacancies arising in the post of assistant registrar has been notified. Stop. The interview is scheduled to be held on 5/11/2024. The learned counsel for the petitioner submits that he seeks similar protection as was granted by this court by the earlier order dated so and so, passed in IA number 1769 of 2024. Error. This matter was listed on last Monday,
Yes, ma'am.
28th, 10/2024, on which date the respondents were permitted to obtain the instruction, and the matter is fixed today. So, we record your submission, Mr. G. Borisola, standing counsel appearing for the respondent, submits that he has received instructions from the registry to submit before the court that an order similar to the order dated 28/6/2024, passed in IA number 1769 of 2024, may be passed if deemed appropriate by the court. Para. Anyone else appearing here in the IA?
No.
Uh, The learned counsel for the parties have been heard. The pleadings available in IA number 7 has been carefully perused. The basic grievance of the writ petitioner slash applicant is that under High Court under Rule 12, under Rule 7(3) of the Guwahati High Court Service Rules 1967, it is provided that the posts of assistant registrar shall be appointed from amongst the state judicial service grade 3 or by promotion from amongst the gazetted officers of the High Court's service belonging to class hyphen Roman 2 within bracket capital B, comma, class hyphen Roman 2 within bracket capital C, comma, or class hyphen Roman 2 within bracket capital D, or from amongst the advocates of not less than 5 years of continuous practice at the bar. Stop. It is the submission of the applicant slash the writ petitioner that the petitioner is presently promoted slash appointed to the post of court officer, which is
Class
the
2C.
class 2C post as is reflected in Schedule 1 to the said rules. Stop. As such, it is submitted that the court post, the class 2C is one of the feeder categories for filling up the post of assistant registrar, and the petitioner, being a court officer, is entitled to be considered. Is entitled to be permitted to apply for presenting himself in the selection and to be considered for promotion slash appointment to the post of assistant registrar in the ensuing selection scheduled to be held from so and so date. So, the grievance of the petitioner is that he is not being permitted to participate in the ensuing selection in view of a rider in his appointment order in the post of senior judicial assistant.
Yes. Now in the post of court
Where
officer,
is that order of appointment?
that is in the writ petition. Page 1818.
Page
Annex of
1,
8.
1, 8.
Last paragraph.
By order dated 18th of April 2016, the petitioner, pursuant to a process of selection, was appointed as court officer until further order from his original post of senior judicial assistant. So, in the said appointment order, it was mentioned that the petitioner will maintain his seniority in his original cadre, i.e., senior judicial assistant, and his further promotion will be considered on that basis. So, it is submitted on behalf of the petitioner that it is this rider which has been uh, 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 which has been referred to by the respondent authority in not permitting the petitioner for participating in the ensuing selection process to the post of assistant registrar. Learned learned counsel for the petitioner submit that The the post of court officer in class 2C is a separate cadre. Class 2C is a separate post with the post of court officer is also a separate post in the cadre of class 2C, in which senior judicial assistant is also a part of class 2C.
Senior judicial assistant is not a part.
Where is it?
That is the schedule. Class 2C, there are 3 posts.
Okay. He submits that it is court officer is one of the posts mentioned in the cadre of class 2C, whereas the senior judicial assistant is a post mentioned under the cadre of class 3 capital A. Stop. It is therefore submitted that in terms of rule 7.3, while class 2C posts, including court officer within court, are shown to be feeder category, the petitioner is not permitted because his seniority is still maintained in the cadre of senior judicial assistant under class 3 capital A. So, learned counsel for the petitioner has referred to the judgment rendered by the division bench of this court in writ appeal numbers in a
Five.
bunch of writ appeals, in which writ appeal number 5 of 2023 was the lead case, whereby the judgment and order dated
28 March. 28
28
March.
March 2024, the writ appeal number 5 was allowed, and it was held that once the post in the original cadre was filled up,
On 20 July 2017.
then the seniority of the personnel of the employee has to be maintained in the post currently in which the petitioner in which the employee is serving. So merely because the rider that his original seniority will be as per the post of senior judicial assistant is mentioned in the appointment order will not be a ground to consider that his appointment / promotion to the next higher post is temporary and is temporary. So, be it as it may, at this stage, considering that the writ petition is still pending, this court considers it appropriate to issue notice permitting the respondents to file their objections, if any, in the meantime.
Well, I'm making number 2 and 3. Petitioner number 1 is the state represented
Petitioner
by
number 2 and 3, who's for state?
None more.
Mr. Mazumdar, you're not for state.
I
All right, state government advocate. Meanwhile, considering the submissions at the bar, more particularly the submissions of the respondent, that the petitioner can be permitted to participate in the interview. As considering the submissions of the counsel for the respondents, that a similar order as was passed in IA number 1769 can be issued at this stage of this court. Permits the permits the respondents to allow the applicant to participate in the ensuing selection process for the post of assistant registrar which is scheduled from 5th of November 2024 as per notice dated 24th of October 2024. Stop. It is made clear that in the event the petitioner is selected for appointment to the post of assistant registrar, his appointment and uh, or slash promotion shall not be given effect to without leave of this court. Stop. Let the matter be listed after 3 weeks on a date to be fixed by the registry.
Right.
And the petitioner counsel will take steps for furnishing adequate copies of the IA along with the writ petition within the course of the day.
my lord, on Monday,
Course of the day. We are giving you orders.
today. Correct.
Course of the day. List accordingly. Then this 1769 has become infructuous.
My lord.
Then 1769 to do. In view of the order passed today in IA number 3290, view of the notification, in view of the notice number, in view of the submission, and also in view of the submission made by the counsel for the applicant that the petitioner, although was permitted to appear in the selection and interview for the post of assistant registrar, ID, what is the notice there in 1768
1769 notice dated 7 June 2024.
by 7 June 2024, the petitioner was not selected. So in that view of the matter, the IA 1769
That's closed.
can be closed and the same is therefore disposed of. Mr. P. Boyso appears for the respondents 2 and 3.
My lord, 2 and 3, and we have filed affidavit in opposition also in the IA.
In the IA, in the writ petition,
We have filed.
you write, matter be listed along with IA number 3290, parties to exchange the pleadings in the meantime. Yes, then
It's another IA, my lord. IA 2291. I appear for the applicants. We want to be implemented in the matter, my lord. Because
All right.
otherwise,
any objections?
They don't have any rule there, but
I have, because I sent near to them.
Yeah.
It's on my object.
but they cannot, the new petitioners, they wanted
Who
to.
are you?
My lord, we are persons who stand above him in the seniority.
Where?
In the in the court offices, my lord, from where he is now getting a
No,
transfer selection. I stand senior to him.
No.
We have been kept out of the process because of the number of posts available and the number of persons being.
No, seniority list is made on what basis?
My lord, see,
my lord, they are administrative officers.
They are administrative officers.
So there are 25 posts of administrative
Administrative
officer
officers.
and 2 posts of court officer.
So
And
they are all in class 2C
plus
we,
2C.
we also had an opportunity to participate in the process.
or extend register.
Yes,
But you have not been given the
we have not been given the opportunity, although.
Then
it
you
was
should have
taken
filed a separate writ petition.
My lord, no, my lord, because for us, the rules as they stand today, the amended rules as they stand today, do not allow such.
Meaning?
My lord, the rules which have been placed before this honorable court on that topic from my lord, they've been amended. There are amendment notifications which require that his seniority has to be considered in the original post. That is what the affidavit in opposition of the Guwahati High Court says.
No.
That's
Vis-a-vis
over-
the judgment of the division bench.
My lord, yes, the division bench judgment relates to the protocol officer.
Whatever.
Same thing.
No, but it is not the same thing. There was
Same
no
thing.
amendment in that particular case, my lord. In this particular, that is what we want to bring to the notice of this honorable court.
The
Well,
ratio of the division bench
Yes,
is that in certain posts,
Yeah.
like protocol officer,
true.
although not discussed,
Mm.
court master, court
Officer.
officer.
Mm.
These are posts where the employer, if they're unhappy with the functioning, will send them back to their original. So they must have a post in the original cadre
To
from
go
which
back.
they are given these responsibilities. So which is originally senior judicial assistant.
Assist-
So from there you become court master, court officer,
Protocol officer.
all that. In the division bench matter, it was a case of protocol officer.
Yes.
But the rider in the appointment
I'm
letter
not
of
on the rider part. Lordship will kindly consider the judgment with Lordship may see. It was with reference to Rule 7.3A. Here the rule is 7.4, which has undergone a amendment in 2015, a notified
That I
amendment.
showed to your lordship.
That notice,
seven,
that
7.3.
7-4.
7.3A is protocol. Lordship will kindly have this. This is what we want to bring on record, madam. The matter may go anyways. We are not on that. The merit I am not.
That your lordship, that they pointed out to me that I should file separate.
7.3 talks about the feeder category.
7.3A is what the division bench judgment refers to. And
It should be one of.
his case is governed by 7.4, where where there is a particular provision in the rule itself. 7.3A did not contain such a rule.
Where is 7.4?
That is what I have just given, madam. That is not in the printed book. I have given the notification of the Guwahati High Court.
My lord,
That
if I-
is 65, page 65 of my.
that way I pointed out,
Yes,
na,
it's
there
an
are
affidavit.
two
The
7-4, my
affidavit-
lord.
The affidavit is a reference. So now, what at this stage I am praying is, let us be impleaded. We'll bring on record our objections. We'll have an argument on merit when the matter
Yes,
is
yes.
taken up.
Yes, very well.
As of
madam.
today, I have not even got this this notification on record from. I cannot bring it on record now, or I cannot have my arguments now. Once I'm allowed to be impleaded, I can bring everything on record.
Alright.
We'll argue it.
Mr. R. Mazumdar, learned counsel for the applicant. Mr. A. Chamua, learned counsel, appearing for the. You are appearing for?
But I'll appear for applicants who tend to be. We are administrative officers,
No,
judicial.
no, no, Mr. Chamua, you are appearing for
I'm appealing from the writ
Writ
petition.
petition,
no?
madam.
red petitioner, respondent, opposite
Four.
party, number
Opposite party,
4
four.
/ red petitioner. Mr. G. Bosho appears for opposite parties 2 and 3.
My lord.
And who appears for government?
Come on, come on.
Mr. G. Begu, government advocate, appears for government, appears for respondent number 1. His IA has been filed seeking impleadment of the applicants in WPC number 2755 of 2024. The applicants claim to be working as what's administrative officer
Administrative officers, and one of them, madam, is
and
Dr.
court master in the Guwahati High Court. Who is the court master?
Court master cannot be in
Okay,
the
madam.
feeder cadre, my lord. Court master does not include in post 2C.
Whatever it is. Applicant number
15, madam.
15.
1-5.
And it is the claim of the applicant that they are under the Guwahati High Court Service Rules 1967, is it?
Madam.
They are also entitled to be considered to the or promotion to the next higher post of assistant registrar. So, however, the same has not been. So you are
Orders passed.
you are
on-
in essence, you are
Well-
supporting the petitioner.
If the rules do not allow it, and he gets the promotion, he goes beyond all of us. That is where one will be
No,
agreed.
no,
Number
no,
one.
no. You are not agreed by the rules.
No.
You are agreed by his interpretation of the rules.
There is a wrong presentation in the court.
All right. It is the submission of the counsel for the petition applicant that the respondent number 4, the writ petitioner, has incorrectly interpreted the rules, and correct interpretation will revealed that the petitioner is not entitled for being considered to the post of assistant registrar. So it is further submitted that the finding of the division bench, the division bench judgment rendered in writ appeal number so and so by order judgment and order dated so and so relates to rule 7, relates to interpretation of rule
7(3)
7(3) capital A,
capital A.
capital A, whereas the present writ petitioner is covered under rule 7(4),
7
which has been
Amended.
recently, which has been amended subsequently to the parent rules. Stop. It is submitted that the petitioner is not entitled to be given the benefit of consideration or promotion to the next higher post of assistant registrar in terms of the rules read with the amendment. Stop. If the petitioner is permitted, then the cases of the present applicants are also required to be considered as they are placed higher in the seniority list over the petition. Stop. Under such circumstances, it is submitted that the applicants are necessary parties and therefore seek implement in writ petition number so and so. Para. Mr. A. Chamwal, learned counsel appearing for the respondent of the party number 4, writ petitioner does not object to the prayer made, nor does Mr. G. Bushaw appearing for respondents 2 and 3 or the learned governor. Accordingly, the I stands allowed. The applicants number 1 to 15 are to be added as
4 to 18.
respondents
4 to 18.
4 to 18 in writ petition number 2755 of 2024 in terms of the order passed today. So I accordingly stands allowed in this full stop. Now in the writ petition, you take the order, earlier order you strike out. In view of the order passed in IA number 2291 of 2024, applicants number so and so are arrayed as respondents number 5 to 15, 5 to 18,
4 to 18.
4 to 18. Stop. The applicants, the newly impleted respondents will file amended post title before the registry within 1 week from today. Stop. Since by order dated today passed in W 2291 of 2024, these applicants are arrayed as party respondent, let notice be issued to the newly impleted respondents. Any objections? They may file their response if any, if so advised, within 3 weeks from today. Matter be listed within 3 weeks. Council to take steps for service of adequate copies on respondent, newly impleted respondents 4 to 80 within 1 week from today.